Welcome back to the Law and Crime Network. I'm Linda Kenney Baden. For the Record today is going to be covering a case that we started following back in May. This is the case of the Hollywood Ripper. You can Google it if you don't know about it. There is Michael Gargiulo. He is accused of killing 22-year-old Ashley Ellerin, his last victim, Maria Bruno, who was also 32, and Michelle Murphy, who actually survived. It is awful. And the reason why this case took a little bit of media attention when they finally figured out who it was because Ashton Cooper was supposed to pick up the last victim. Her name is Ashley Ellerin, and then Ashton Cooper actually knocked on the door, and she didn't answer the door because she probably was already laying down bleeding by then. But there were cameras in the courtroom for the opening statements in California. Cameras were not allowed for the trial. So we're going to play a little bit of Dan Eckerman. He is the prosecutor, his opening statement, which will lay out this case for you. Well, we are hearing some horrible testimony about the slaughter of one of the earlier victims who obviously fought for her life because she had Michael Gargiulo's DNA under her fingernails, Gene Rossi. I mean, the pall in the courtroom is just beyond. What do you do about it as a defense attorney? Well,
I'll get to that, but as a prosecutor, he was magnificent describing the death of Tricia, how slowly he paused. He mentioned that he bragged, and then you're saying, okay, how are you going to prove that? Then he goes, and we found DNA under her fingernails. So the evidence of him bragging is going to be totally believed. If I'm a defense attorney, I got to tell you, the DNA is very troublesome for Trish. I don't know about the other victims, but the DNA is hard to get over.
Well, again, Roger Foley, this thing called DNA back in when these happened in the earlier 2000s, okay, that has become a tool that the prosecution and defense now embrace, correct?
Absolutely. I mean, the DNA is there. It puts the person there. It puts the defendant at the scene of the crime. So it's important. And if it's not there, think about it. If it's not there, you go, my client wasn't there. So it helps both in both the prosecution and defense use it if they have it.
And look at the picture of him that our viewers are seeing. We've heard about Trish, his first victim. He snapped her arm, Gene Rossi, snapped her arm. I mean, you're talking about what some may describe as pure evil, correct?
Yes, and that the snapping of the arm also corroborates what the prosecutor said. He was trained in martial arts. He was very strong, he was very agile, and that snapping of the arm is evidence that he used his athletic skills to prey and kill his victims.
Well, as he flew with his DNA across country and had more victims, let's listen to the prosecution who are going to talk about the multiple wounds on the last victim, Ashley Ellerin, because there were a lot. Well, I, as a person who deals with criminal defendants a lot, both from the prosecution side earlier, from the defense, Gene Rossi, Roger Foley, I have chills running down my whole body sitting here in this anchored seat. The amount of depth of obviously fear over a 15-year period. What do you think of his opening, Gene Rossi?
You know what's amazing, and I hope your chat room picks up on this. We just finished looking at it's the defense or the closing rebuttal, if you will, in the Rosenbaum case. This obviously is an opening, but it's a tale of two styles. Sometimes each style is appropriate for that case. But what was beautiful about this opening by Mr. Ackerman, Dan Ackerman, is he wasn't inflammatory. He wasn't outrageous. There was absolutely no comment he made that was even arguably over the line, and all he did was present the facts and let the facts compel his argument.
Right. He expected Roger Foley. He said, I expect to prove, I expect there will be evidence. Well, I've read the autopsy report of Miss Ellerin. She had like 12, if I recall. Yes, 6 wounds to her right hand, 6 wounds to her left hand. They appeared to be defensive wounds, some bigger than others, but she appeared to have fought her killer and saw her killer. That makes it even more egregious to a jury, doesn't it?
Absolutely. I mean, this is the definition of malice, right? An evil intent. When you hear these facts and the way he pulled you in on the opening, you find that with very experienced attorneys. They don't have to yell. They don't have to shout. They don't have to insult. They simply tell the facts and bring you into the story so you're there.
Right, and as a matter of fact, the words evil and wicked that Daisha Young used, she said she thought the Rosenbaum case was the worst one she ever had. Let me tell you, I think those type of adjectives also apply here. So when we come back, we're going to have to see what the defense does to represent their client after that incredibly bone and spine-chilling opening. Stay tuned. Welcome back to the Law and Crime Network. Ashley Ellerin was one of the victims, allegedly, of Michael Gargiulo, a serial sex thrill killer who supposedly killed 3 women and attempted to murder another woman. He's on trial right now in California. They opened in early May. They're expected to close tomorrow. The prosecution, Mr. Ackerman, had a compelling opening. We here at the Law and Crime Network were all mesmerized. But let's see if the defense team, which consists of Daniel Nardoni and Dale Rubin, can have an equally compelling opening representing their client, Mr. Gargiulo, who has the presumption of innocence. Okay, so this is how the defense began.
Regarding
Roger Foley, okay? One of the victims here, Trish, is there for identity purposes to prove that the identity of Gargiulo is the person who this California indictment has charged. How does that differ, if anything, in the burden of proof in a trial?
How does it differ? I mean, the state still has the burden of proof, but think about how helpful it is to have someone who is a victim of a crime who was being cut and slashed and survived it to be able to come to court and testify about the exact person who she identified as being a neighbor, the one who did this to her. I mean,
let me just tell you, that's Ms. Murphy. She is charged in this indictment, but Patricia, as they called her, right? She was from a different jurisdiction, so they're using that to show that her claim with the DNA also related to Gargiulo for a pattern and practice, if you will, right?
Correct. The modus operandi. He did the acts the same way by going in and stabbing and slicing.
Okay, so then Gene Rossi, you are sitting there. The one thing I haven't heard my defense attorney say, and I try to tell defense attorneys you must do this, my client is not guilty. Not that just, well, you'll hear that there was no evidence. You'll hear that maybe Ashton Kutcher was the person to last year. You'll see that no one broke in. My client is not guilty. Doesn't that tell you there's a weakness here?
Oh my
God, I'm making both my guests become speechless today.
Let's put it this way. He could have said in a more demonstrative manner that as my client sits there right now, he is innocent for one major reason under the Constitution of the United States. At the end of the day, the government is not going to meet its burden beyond a reasonable doubt. And if that is the case, he is innocent. That's what I would have said.
Well, Roger Foley, when you start relying on the Constitution, I always say that like the jurors say, okay, you're guilty. You can say that the state can't prove their case beyond a reasonable doubt, and the reason they can't prove their case beyond a reasonable doubt is because my client is not guilty. What's the difference?
Well, you can say that, but the problem is someone's holding the goods, right? You heard the prosecutor say, we have DNA evidence, we have a witness. But what's the defense going to say to that there's not DNA? They can't lie to the jury. They have to deal with the facts that are given to them. So it's very difficult for him to just simply say we're not guilty, hence the Constitution argument.
So, Gene, 30 seconds we have about. So then the answer is you're stuck with the case you have. You give your client the best defense, but maybe this guy is guilty of these horrible crimes, right? But you don't say that as a defense attorney. You say the state then has to prove it.
Let's put it this way. It goes to poker. You get 5 cards. Their 5 cards aren't the best. And you do the best you can with what you've been dealt. That's all you can do.
Gene, you're giving my avocation away because I play poker. You get 5 cards, you know, in Texas Hold'em, 7 and 7 card stud. And yes, you play the cards that you have, but sometimes you can play them pretty much, a lot better than other people. But here, I suggest that these victims are so slaughtered, and the evidence that we've heard so far, well, just in the openings, is so good. Well, stay tuned. We'll tell you if it's really good after this break.